Seller cannot refuse to sell for use as a drug and alcohol rehabilitation home. Issue: the offer from the buyer has additional language stating that seller understands that the property will be used for a drug and alcohol rehabilitation home. The seller owns 3 other homes in the subdivision and does not want to accept this offer. Can the seller refuse to accept this offer because the buyer intends to use the home as a drug and alcohol rehabilitation home? Answer: no. Under the fair housing laws, a seller cannot refuse to sell a residential property to anyone with a physical or mental impairment. A physical or mental impairment includes drug addiction, other than addiction caused by current illegal use of a controlled substance, and alcoholism. CAAC R10-2101-17, C. I. 2. Therefore, if the drug and alcohol rehabilitation home would be occupied by individuals that are no longer engaged in the illegal use of controlled substances, any refusal to sell the home to the buyer would be a violation of fair housing laws. Seller not obligated to bring premises into compliance with swimming pool barrier laws. Issue: the buyer has presented an offer to purchase a home with a swimming pool. There is no fence around the swimming pool. The buyer has small children and has requested in the buyer's offer that the seller constructs a fence around the swimming pool. The seller has refused to accept the buyer's offer. If a buyer has small children, is the seller required to accept the buyer's offer? Answer: probably not. The fair housing laws do not require a seller to construct fences for the protection of small children. Note: under the AAR Residential Resale Real Estate Purchase Contract, the buyer is required to pay for any costs in constructing a fence or otherwise complying with swimming pool barrier laws. If the buyer does not want to pay these costs, the buyer can cancel the AAR contract during the inspection period. Seller prohibited from disclosing to potential buyers a drug rehabilitation group home issue. One of the homes in the seller's neighborhood is a drug rehabilitation group home for recovering drug addicts. Is the seller required to disclose to potential buyers this drug rehabilitation group home? Answer: no. Recovering drug addicts or recovering alcoholics, but not current drug or alcohol users, qualify as a member of the disability protected class under the fair housing laws. Therefore, not only is the seller of the home not required to make the disclosure, the seller is prohibited from making any disclosure of a drug or alcohol rehabilitation group home in the neighborhood. The death of the owner generally terminates the listing agreement. Facts: a property is listed with brokerage A. The owner of the property passed away, and now his daughters want to list the property with brokerage B. Issue: is the listing with brokerage A still valid? Answer: probably not. The general rule is that upon the death of a party to a personal services contract, e.g., upon the death of either the seller or the listing broker in a listing agreement, the personal services contract is terminated. Therefore, absent extenuating circumstances, the daughters are entitled to enter into a new listing agreement with a new broker after the death of their father. Tail clause starts at time of early termination of listing agreement issue. The 6-month listing agreement has a 90-day tail clause. After 4 months, the seller is unhappy with the number of showings of the seller's home. The seller and the listing broker then agree to a mutual cancellation of the listing agreement, but do not address the 90-day tail clause. Within 90 days after the mutual cancellation of the listing agreement, the seller signs a contract to sell the home to a buyer who was shown the home during the first 4 months of the listing agreement. The seller did not list the property with a new broker. Does the 90-day tail clause apply if the seller and the listing broker agree to cancel the listing agreement early? Answer: probably. The 90-day tail clause begins to run at the time that the listing agreement is terminated, even if the seller and the listing broker agree to an early termination. Note: listing agreements generally provide that the tail clause of any time period does not apply if the property is listed by the seller with a new broker. Surviving spouse entitled to enter into new listing agreement issue. The home is owned by the husband and wife. the husband signs a 6-month listing agreement with the broker. The wife does not sign. 1 month later, the husband dies. Can the wife enter into a new listing agreement with another broker? Answer: probably. Although the wife did not sign the listing agreement, the wife was bound by the listing agreement entered into by the husband, because a listing agreement is a personal services contract, not a real estate contract. Either spouse is entitled to enter into a listing agreement on behalf of the marital community. Inasmuch as a listing agreement is a personal services contract, however, upon the death of the husband as the signing spouse, the listing agreement probably terminated. The general rule is that, upon the death of either party to a personal services contract, e.g., upon the death of either the seller or the listing broker in a listing agreement, the personal services contract is terminated. Therefore, the wife was probably entitled to enter into a new listing agreement with a new broker after the death of her husband.